For our next case, we have the case of Shandle Riley versus the Hamilton government, Deputy Daniel Wilkey and Deputy Jacob Goforth. So what we're going to read about is how during a traffic stop, a group of police officers decided it was a good idea to forcibly convert the person who was being detained into Christianity by forcibly baptizing them. So we're going to read this decision from the State of Tennessee Circuit Court and read a little bit about the facts, and let's get started. On February the 6th, between 10 and 11 p.m., the plaintiff was alone driving. Plaintiff pulled into a gas station. Wilkey was also at the same gas station. The plaintiff exited the vehicle, entered the gas station, and paid for cigarettes and gas. Plaintiff completed her purchases and drove away from the gas station to the residence of Diane King, where she intended to visit a child. As the plaintiff pulled into the driveway, Wilkey initiated a traffic stop of plaintiff without any justification. Wilkey approached plaintiff as she sat in her vehicle and ordered plaintiff to exit the vehicle. Without justification, Wilkey told plaintiff she believed plaintiff possessed methamphetamine. How? How are you coming to this kind of conclusion? How? Plaintiff complied with the order to exit the vehicle. Without justification, Wilkey then conducted a search of the plaintiff's person by feeling through the clothing, her breasts, abdomen, buttocks, inner thigh, and crotch. Outstanding. Without lawful justification, Wilkey further ordered the plaintiff to reach under her shirt and pull out her bra and shake it. Plaintiff asked Wiley if a female officer should not be present to conduct the search, and Wilkey stated the law did not require a female officer to conduct the search. Yay. Wilkey, without any Miranda warnings, asked plaintiff if she had done anything illegal in her vehicle. She said that she had a roach and a packet of cigarettes, and she gave Wilkey the pack. A second identified deputy arrived. He described this unidentified deputy as a white male with a bald head. During the search, Wilkey continued to insult plaintiff, telling her that she was a piece of shit. Plaintiff was lying about not having other drugs. Wilkey told plaintiff that she knew she had a criminal record. Other than the roach, Wilkey did not find any contraband. Here's where it gets interesting, guys, in case you're waiting for the interesting part. Wilkey then approached the plaintiff and asked her if she was saved and believed in Jesus Christ. Plaintiff said that she believed in Jesus, but she was not saved by her own choice. Wilkey then told plaintiff that God was talking to him during the vehicle search, and Wilkey felt like the Lord wanted him to baptize the plaintiff. Wilkey further told plaintiff that he felt the Spirit. Oh, man. Sometimes during the dialogue about baptism, the unidentified deputy left the scene. Wilkey told plaintiff to go inside the residence and get 2 towels for baptism. Wow. Wilkey told plaintiff that she would let him baptize her. She would only issue criminal citation and not take her to jail. Wilkey further told plaintiff that he would also go to judge court and speak on the behalf of the person. Wow. Wow. For those of you playing at home who think to yourself, might this violate the First Amendment? Yes, it might violate the First Amendment, yes. At no time did Wilkey ever court plaintiff to speak on behalf of the judge. Plaintiff went inside and got 2 towels. King, who was inside, asked the plaintiff why she needed towels, and plaintiff told King that Wilkey, the police officer, said he would not take her to jail and would go to court and speak to the judge if she allowed her to baptize her. King asked plaintiff if it was safe, and plaintiff said she was not sure, but she'd go out to find if being baptized would help her avoid going to jail. Plaintiff went outside with 2 towels, and Wilkey told her to drive to her vehicle and follow him. He did not say where he was taking her. At no time did plaintiff feel free to simply ignore the request. Plaintiff followed Wilkey, the police officer, to a boat ramp at Soddy Lake near the corporate limits of Soddy Daisy, Tennessee. Police officer Goforth arrived in his patrol car at the same time as Wilkey, and plaintiff arrived at the boat ramp. Goforth exited his vehicle and stood by and observed Wilkey and the plaintiff. Wilkey told plaintiff that Goforth was present because in order for a baptism to be valid, a witness must attest to the ritual. Okay. Wilkey then nearly stripped naked with only his boxer shorts on. Wilkey gave plaintiff the option to strip too, but plaintiff declined. Okay, wow. Okay. I didn't really understand what I was reading there for a second. Wilkey, the police officer, then nearly stripped naked with only his boxer shorts on. The police officer nearly stripped naked. Great. Wilkey then led plaintiff into near waist-deep water. placed one hand on the back, other hand on the breast, and completely submerged plaintiff underwater. Wilkey had the plaintiff under water for several moments, then with his hands still positioned, raised him from the cold water. Shivering uncontrollably and felt violated. You don't say. Wilkey used one towel to dry him off while the plaintiff used one. Wilkey returned the towel to plaintiff. Officer Goforth smirked at plaintiff as he's drying herself off. At no time did Goforth ever intervene to stop Wilkey, nor did he ever report Wilkey's action to anyone in the chain of command. Wow, this is special. I'm happy on levels that are hard to fully express that I'm reading this, because the absurdity of it is just so comical. It's mind-numbing, but I'm happy to share the absurdity with you. This is very, very illegal, as I'm sure you can appreciate. So as some additional flavor, there are some additional things that have also happened in this county concerning other people, so we will briefly cover some of these instances. So we've got the case of Rodney Terrell. Rodney Terrell unreasonably used force, and they wrote up a false justification, and the county failed to discipline this person. Despite a finding from Internal Affairs that they used excessive force, the sheriff merely stated, the police needs review and bear for clarification. Despite a finding by the Internal Affairs of excessive force, they did not suspend or terminate Terrell. So, as addition to our prior story, where the police in their own internal reviews found no problem, even where the police found in their internal review force a problem, the sheriff ignored the internal review process. That's just great. The story of Daniel Hendricks. Savagely assaulted a fully handcuffed and shackled prisoner. That's great. Captured on video. Super. Hendricks lied to the sheriff department about his assault. Although criminal charges, they were eventually dropped based on a false claim. Police lying. I'm telling you, this is apparently a problem. Subsequent to the criminal charges, the county returned the officer to full duties. So despite beating savagely a suspect who was in handcuffs at the time, he was returned to duty. Great. The story of Edmund Kilpatrick, fired by the county sometime and deputy sheriff. Prior to employment, he was a defendant in an order petition. This petition was, at the time, a public record. In the petition, it was claimed that he forced a way into a residence. He stands accused of killing Christopher Sexton in a criminal case. Stands accused of beating another person. In this case, while handcuffed and on the ground, he's beating and pummeling. The video record happened. The video record went viral. It was not until December the 19th that the county, through its sheriff department, placed him on suspension with pay. He's facing homicide charges in federal court, but he's suspended with pay. Great. That's very reassuring. The story of Sheriff Jim Hammond. While addressing civic leaders about black gang members, Hammond stated the following: "We need to run them out of town, put them in jail, or send them to a funeral home." Great. In response to conduct, in response to a video recording of a beating, strip search, and anal cavity search of a handcuffed suspect, he stood by the deputies, the same deputies that were seasoned officers, good officers, and stood by their ability and training. Really? Okay. Despite the questionable killing of an unarmed man by a gunshot to the head, that would qualify as questionable, yes. They approved the hiring of the person as a deputy for the county. So even though he shot an unarmed person in the head, we're going to hire him as a police officer. Okay, good. Consequently, by setting an example through these cases, the county created an environment that allowed the individual defendants to believe their abusive behavior would not be monitored, investigated, nor punished, and was tantamount to a policy in the county. I would tend to agree. This does not strike me as a well-functioning police department. So what are we suing for? Well, we're suing for violations of 42 U.S.C. 1983 for freedom of religion. Well, I don't know, guys. I don't know. How could it possibly be a freedom of religion violation to forcibly baptize someone? I'm just not seeing the connection, guys. I'm not seeing how it's a violation of fundamental civil rights to be forcibly baptized. I don't know. Maybe it's a stretch too far, guys. What do you think? I don't know. I'm not seeing it really. The individual defendants had a non-delegatable duty not to force plaintiff into participating in a religious ritual. Yes, I would think so. The officer had a duty to intervene. Yes, I would think so. The individual duties had a duty to report the misconduct. I would think so. No reasonable law enforcement officer would have acted in this manner. I concur. In addition, the failure of the officers to intervene and stop others and failure to report the misconduct constitutes a joint effort. Yep. The county's continued employment and the county's failure to discipline them in any meaningful manner creates an atmosphere that other employees, including the defendants, could act in a similar manner. I don't know, guys. Is it more disturbing to you that the police officers forcibly baptized this person, or is it more disturbing that the county, aware of it, failed to discipline them in any way? I don't know. It's kind of a hard call. They're both pretty bad. I'm not sure which is actually worse. They're both pretty horrible, though. It gets worse. The county's promotion of the person to lieutenant after the unnecessary use of force create an atmosphere, including individual defendants could act. So they promoted a lieutenant. They promoted someone after unnecessary force. Not only did they not discipline the person after unnecessary force in a related case, they promoted them. That's real encouraging. The county's employment of Kilpatrick, despite his violence against women during the commission of a felony, the police force employed someone with a history of domestic violence during the commission of a felony. Okay. The continued display of violence in the unnecessary killing, the promotion to a detective position, and delayed suspension despite overwhelming video evidence of the propensity to violence against a helpless individual created an atmosphere. Yes, I would think it did. This is just a story of competition for horror show. Which horror show do you find to be the most horrible? That's what this case is all about. Which of the horror shows is the most horrible of the horror shows? Is it the most horrible horror show when we forcibly baptize someone, or is it more horror show when we don't discipline those people, or is it more horror show when we employed yet a different person with a history of domestic violence and then promoted them? I don't know, guys. What do you think is the most horrible? Hard to tell. The county's employment of the person, despite a history of violence against an unarmed person, created an atmosphere. Yes, I would think it did. The failures of the county set forth in the previous paragraph set forth a deliberate indifference on the part of the county, creating an environment that allowed misconduct to occur. It constitutes a policy and was direct and proximate cause. Yep, sounds that way to me. The county hired Kilpatrick despite the 2006 history of extreme violence. The county's employment was either in full knowledge of the county's incident and thus condoned, or was a product of shipshod vetting, probably the latter to be quite honest, but that's still not an excuse. It probably was shipshod vetting. Either way, the county's employment of Kilpatrick constituted a message that no matter your conduct, you can become employed with the county as a deputy sheriff. Yep. The failure of the county in regard to this employment created an environment that allowed misconduct. The individual defendants acted under color of law. Yep. Count 2. Failure to protect and render aid. Both individual defendants had non-delegatable duties to intervene and protect the defendant from forcing the plaintiff into participating in a baptism against their will. Or I'd argue even a baptism with her will. It still would constitute a First Amendment violation for the government to conduct a baptism. I don't really care that much whether she was consenting or not, to be quite honest about it. The county's promotion of Terrell to lieutenant after unnecessary use of force created an atmosphere. The county's employment of Kilpatrick despite violence created an atmosphere. The county's employment of Wilkey despite violence against unarmed person created an atmosphere. Count 3, unreasonable seizure. Wilkey had no lawful basis to coerce plaintiffs into obtaining towels, following Wilkey to a remote location and participating in the baptism in exchange for going to jail. No reasonable law enforcement officer would have acted in this manner. Count 4, unreasonable search. Wilkey had a non-delegatable duty to refrain from searching plaintiff without probable cause by touching her genitals in such a manner as to constitute a criminal sexual battery. Sounds that way. No reasonable law enforcement officer would have acted in this manner. I tend to agree. Count 5, negligence. The individual defendants at the time of events averred in this complaint acted under color of office. The Tennessee Code allows anyone incurring any wrong injury to bring suit. The Tennessee Constitution prohibits treatment of plaintiff upon arrest and confinement with unnecessary vigor. The individual defendant's failure to protect plaintiff from one another, not to force them to engage in baptism, not to seize plaintiff without probable cause, not to search plaintiff, engaged in unreasonable injury. Battery. Yep, the individual defendant's concurrent act is a battery. I tend to agree. Count 7, battery. Wilkey's acts and omissions with regard to the search as averred were not based on any lawful execution of duties as a law enforcement officer. Rather, Wilkey acted with intent to inflict physical and mental harm and for own sexual gratification. Kind of sounds that way, yes. Count 8, assault. The individual defense acts and omissions as averred were not based on lawful execution of duties. Count 9, assault. The acts and omissions with regard to the search as averred were not based on lawful execution of duties. Count 10, intentional infliction of emotional distress. Intentional infliction of emotional distress is a pretty hard tort to prove. I find absolutely no problem whatsoever in finding proof in this case, though. We're well beyond the threshold for intentional infliction of emotional distress. So, despite the fact it's a pretty hard tort to prove, I think we're there. Despite full knowledge of pain and harm during the physical encounter, they continued in the actions. No reasonable person would engage in it. Wherefore, we request the following relief. The omissions of the county constitute willful and wanton indifference and deliberate disregard to constitutional rights. I agree. The individual defendants commits acts with actual malice. I agree. The court to enter judgment against the defendants and award $1 million in compensation, award $10 million in punitive damages, and award other costs as may be warranted, and will allow for a jury trial. So yes, I would think so. So that is the case of Shandle Riley versus Hamilton County and Deputy Daniel Wilkey and Deputy Jacob Goforth. So we learned a couple things, that yes, it is in fact a violation of your civil rights to be forcibly baptized. If you were not aware, it's a violation. And I would argue it's a violation of your rights to be willfully baptized, because the government should not be doing that. We have a separation of church and state. If you want to be baptized, I have no problem with that. If you even want to be baptized in Deputy Daniel Wilkey's or Deputy Jacob's Goforth's church, I have no problem. If you want them to do the baptism in the church, I have no problem. If you want to do it on your off time, I have no problem. I, however, have massive problems with them doing it as part of their police function, which is clearly what happened in this case. And as amazing as it is, that may not be the worst of the horror shows. We learned that in this particular county of Hamilton County in Tennessee, the horror shows just continue, with police officers being employed despite histories of domestic violence, despite histories of shooting people in the head who are unarmed, despite histories of beating up suspects who are handcuffed. So it's just a race for what is the biggest horror show, but it looks like this is a horror show. If the facts are anything even remotely close to what has been pled here, I think that these people should win. It is qualified immunity. I don't think it's going to work. I don't think we need to say it's clearly established. The government should not engage in the establishment of a religion. I seem to remember reading that once. And so I don't know whether or not these amount of damages is warranted, but that's for a jury to decide. And were I on this case, I'd be somewhat inclined to give them what they asked for, because this is pretty horrible. So we will see what happens next.